All right, we'll call back to order and we have a quorum. So the first matter of business that we have is the approval of the minutes from September 12th of 2023. You have had those received in your packet. Is there a motion to accept the minutes? Second?
Second.
We have a second. Any discussion? All those in favor of approving the minutes from September 12th, say aye.
Aye.
Anyone opposed? Okay, the minutes are approved. Now to the guidelines subcommittee report. Waiting for Judge Avery to finish.
Oh, no, I'm good.
Now I'll kick it to you, Judge.
I always wait until after my report. All right, well, good evening, everyone. Thank you. Are we still public facing at this point?
Yes.
Okay. So I just want to say, as the chair of the guidelines subcommittee, that our subcommittee, we met on November 15th, and we are, myself, Judge Avery, Rick Fincy, Mr. Harvey, Senator Sidnor, and the chair of the Guidelines Commission, Judge DeLeonardo, joins us for those subcommittee meetings. We generally review the proposals and questions that come into the commission and reports from the staff, and we make recommendations on those questions and proposals, and then we report out those recommendations to the full body of this commission. Some of those recommendations are essentially status reports. Often they are action items that have to be voted on. So the subcommittee doesn't make the final decisions. We only do a first pass review on these issues, but the full body of this commission reviews all of the matters that the guidelines subcommittee reviews. So with that being said, as I stated, we did meet on November 15th, and we have 3 items for your review tonight. 2 of them are status only, and 1 is an action item. Having said that, I'll turn it back over to Dr. Soule to describe with more particularity those issues.
Thank you, Judge Avery. So I will provide the introduction for agenda item 4A, which is a follow-up on the presentation we just heard during the public comments hearing about the request from the Office of the Maryland State Prosecutor. And then Sarah will be providing our introduction for agenda item 4B. And then finally, Lydia will be presenting the issue with 4C. So with respect to agenda item 4A, the Office of the Maryland State Prosecutor Enhancement Request for Abuse of Position of Trust, I refer you to the corresponding memo that you should have all received. You may recall that at this commission's May 9th, 2023 meeting, the staff presented a letter from the Office of the Maryland State Prosecutor detailing the office's request that the commission consider an enhancement for offenses involving an abuse of position of trust. This commission heard testimony from 3 members of the Office of the Maryland State Prosecutor during the public hearing today. The commission referred this request to the Guidelines Subcommittee for review. Today, the subcommittee suggests to the commission that the legislature may be better informed and better positioned than the Sentencing Commission to address penalties for misconduct in office. So for a little bit of background, I want to fill you in on the staff's work and how the subcommittee arrived at this position that is presenting today. After the last commission meeting, the Sentencing Commission staff met with the Office of the Maryland State Prosecutor staff to discuss the logistics of the proposed enhancement and to review sentencing guidelines data for Office of the Maryland State Prosecutor convictions and also for all misconduct in office offenses for which the Sentencing Commission collects data. After reviewing these data and the effects of the possible enhancement, the Office of the Maryland State Prosecutor proposed a 2 seriousness category increase for any offense involving a defendant who abused their position of trust in the commission of an offense. This enhancement would require the prosecutor in the case to identify whether the offense or offenses involve abuse of a position of trust. And if there is an abuse of a position of trust, the corresponding seriousness category for that offense would then be adjusted by 2 levels. The memorandum that you receive presents the data related to offenses prosecuted by the Office of the Maryland State Prosecutor and all convictions for misconduct in office. This memo also includes illustrations as to how the guidelines would be impacted if the seriousness category for an offense involving an abuse of position of trust were increased by 2 categories under the Office of the Maryland State Prosecutor's proposal. At its November 15th meeting, the subcommittee first heard a presentation from Deputy State Prosecutor Sarah David and her colleagues, who you heard from earlier, about the importance of this issue. And then the subcommittee discussed possible options for the proposed enhancement and how they would impact the sentencing guidelines. The subcommittee was amenable to the Office of the Maryland State Prosecutor's argument and the proposal for an enhancement. However, as was discussed during the public comments hearing earlier, the subcommittee was concerned that if the commission adopted an enhancement, this would be a prescriptive change to the sentencing guidelines, which would be contrary to the primarily descriptive nature of the guidelines. The subcommittee discussion then focused on the misconduct in office offense, a key offense involving abuse of position of trust. Currently, misconduct in office is classified as a seriousness category 5 offense. Seriousness category 5, for reference, is most commonly associated with misdemeanor offenses with a 5-year statutory maximum penalty. The subcommittee noted that judges are mostly consistent with the current sentencing guidelines, meaning their sentences are mostly consistent with the current sentencing guidelines. As we noted earlier, 90% of sentences for misconduct in office are guidelines compliant, with more departures above 9% versus below the guidelines at 1%. Though this pattern is partially a function of probation being the lower range for the overwhelming majority of these cases. A few subcommittee members thought that the penalty for misconduct in office may be more of a legislative issue than a guidelines issue, as the sentencing guidelines are intended to be primarily descriptive of current sentencing practices. Commission staff noted that the classification for misconduct in office is more open to judgment than most offenses. This is because misconduct in office is a common law offense, so it has no statutory maximum penalty, and maximum penalties are the primary driver of offense classifications in the guidelines. Ultimately, the subcommittee voted to table the enhancement issue and share with the commission the Office of the Maryland State Prosecutor's requests and the concerns that they noted for further discussion. The subcommittee suggests to the commission that the legislature may be better positioned than the commission to address penalties for misconduct in office. Misconduct in office is currently a common law offense. The legislature could, if it wishes, codify misconduct in office and assign it a penalty. So I'll end there. That was the recommendation. This is a status report. Certainly open up the table to any further discussion.
I have a question. I thought that and maybe I have it wrong, I thought that the state prosecutor's request was twofold. One, that the guidelines be upped, and the other, that at least there be a classification so that the data could be collected. Is that?
I think you've accurately captured that. Yes, that was the request. The discussion, the subcommittee did take it in a slightly different direction by adding kind of, I would say a third would be, should misconduct in office be considered for codification? And there was even a proposal to discuss whether the seriousness category for that might be amended. But again, the primary driver for seriousness categories, right, has always been the maximum penalty. But this is a common law offense, so the maximum penalty is, life. Anything's reasonable. It's not a 5-year or 10-year penalty. So right now, it is categorized as a Category 5 offense, which I noted is most commonly associated with misdemeanors with 5-year statutory maximum penalty. So to the extent that misconduct in office may be considered a more serious offense, that was something that the subcommittee discussed, whether it would be appropriate to consider a different seriousness category classification for misconduct in office. But their request, which you've categorized correctly, was much broader. They wanted an enhancement for all offenses that involve an abuse of a position of a trust beyond just misconduct in office offenses.
But I thought their request was that even if they aren't able to get the enhancement, they believe that collection of the data would, I guess, increase the awareness that judges are sentencing in a particular way.
I think they
Am I
did
right?
add that during the public hearing today. They didn't, am I wrong? I don't remember them specifically citing that before.
Yeah, I was confused actually, because I don't remember that aspect of the presentation in the guidelines subcommittee meeting. And that, I don't want to interrupt you. It's an interesting request.
I thought that that's what, because I wasn't on the subcommittee, so I thought that they were asking two things. If we can't get one, we can maybe at least have the collection of the data, and I felt what they were saying was the collection of the data would increase a judge's awareness of how they are sentencing for, in cases of individuals.
So what I
But
took,
maybe I'm wrong.
what I took from what she said was that if there were an enhanced, like a conditional enhancement, is that like that at least if that were identified prior to the finding that there was a violation of public trust, that itself would provide relevant
Right.
data, as opposed to a standalone data point, which I don't think would be appropriate for us to be including. So that's how I interpreted what she was saying.
Right, and that was, just came up tonight. So that wasn't, the subcommittee didn't previously vet that because I'm off the top of my head, I would have to think about how we would collect that data. You know,
I mean,
right.
There's sort of a collection with a departure reason, but I think we can all recognize that judges are not always listing that, and they may not depart. So
They aren't-
it may be
they
a
aren't.
miss. it
And
may
you have
be
to get to
that
departure.
Right.
trust, but it may not be a departure, so they wouldn't capture that. So I mean, I think that definitely is one issue perhaps to look at. The other issue, just real quick, Mr. Harvey, if I can, and it came up at the end of the subcommittee, which was interesting, because I think we were all sort of like, okay, this is classified, misconduct of office is classified the way it is. When I heard that it was a common law offense, I thought that made me be a discussion of relooking at as to how is that classified in relation to others in that category? Because misconduct in office certainly would carry that breach of trust in every case. I mean, a little bit, if you're arguing breach of trust, embezzlement is always going to have that. So we'd be adding on top of the crime that's already listed. But that was something I thought maybe worth looking into a little bit because it came up as whether or not that could be in some way looking at the classification of that. Mr. Harvey?
Well, kind of stole my point there.
Oh, I didn't mean. Sorry. Forget I said anything.
I was at the subcommittee, I was not prepared, and I'm not prepared today to say that we ought to consider across the board enhancement for abuse of position of trust. That opens up all kinds of issues. For example, in a child abuse case, is a parent a position of trust?
Right.
Probably, I think, and I'm not sure that that's something that we would be prepared to recognize. But I do believe we ought to take a hard look at the crime of misconduct in office. I think it is underscored. It's a category 5, which is a relatively low type of property offense, frankly, is where you normally see it. These misconduct, it's not just a position of trust that's violated, it's a position of public trust. It's enhanced even more, and the maximum punishment is whatever's not cruel and unusual. So it's not an 18-month misdemeanor or a 5-year misdemeanor. It's an equivalent, frankly, of some of our felonies. It's a category 5. I think we ought to take a hard look at elevating it to perhaps a category 4 or even a category 3. It's not going to bump the guidelines up that much, but it would give recognition to the unique character of that offense. That's what I would
And I
hope.
would just add, it is a bit of a struggle because you know, we can come up, that's why when I asked the question about the broadness of it, I mean, you can argue a position of trust for about anything. I think about the bookkeeper who works at the company. I mean, that's going to be a position of trust.
Animal cruelty case,
Correct, all of them.
dog tender, dog sitter.
But also there
They're
is
not human
an
victims.
element when you have an example of, for example, an assault that occurs between two individuals at a bar versus, someone who is in custody of a detention center employee who's intentionally assaulting an inmate. Those are going to be the misconduct type cases. And so I do think perhaps that may be worth taking a look at to see, because I just remember at the end of that discussion, which was a fabulous discussion, I think we were all kind of like, yeah, this is more prescriptive. But that part I think may not be. So anyway, I'm Mr.
Yeah, it struck me as troubling and a bit ironic that one of the principles of them coming here was that they were, unhappy with the type of plea agreements they could negotiate. That's troubling to me. That this comes to the commission for our help in somehow changing the balance of power in the plea negotiation process, which for those of you who haven't been on the committee as long as I have, has been a point where I've raised on the defense side on so many arguments that it was unfair, something that we might be doing because it changed that balance of power in the plea negotiation process. And when it came from the defense side, it wasn't as important as perhaps maybe we're looking at it from the side of, the prosecutors in this situation. I think that they should be officially going to the legislature to get more power, more harsh sentences, more recognition of the fact that these are abuses of position of trust, and not coming to us for that.
Yeah, there were two things that came up in the guidelines subcommittee that I feel like didn't really come out as well today. And one is, Ms. David said the thing about implicit bias, but I think really didn't expand on that. And I think that is an interesting point that they make, that because the defendants in their cases and the offenders tend to be people who don't have criminal records and are otherwise upstanding members of the community or perceived as such, that there's a function of an unwarranted lesser sentence given the severity of their offenses. And I think that's, and also the kind of conundrum, which is in the cases that involve sexual misconduct, that so often they have collateral reasons for not wanting to go to trial. The victims don't want to go to trial. And so therefore they are unable to get to the point where they're before a judge to argue for an upward departure. And I think that is a practical problem for their cases, and it's that's an issue. I personally think that is the kind of issue that needs to go to the legislature, and I don't think I really understood the argument from the state prosecutor's office that it's so impossible to go to the legislature on this, and that you would have to list every possible crime. But is that really true? I mean, for example, if you have a use of a handgun in the commission of a crime of violence, that is a sentencing enhancement. Essentially, it's an offense that makes a reference to crimes of violence. Crimes of violence are defined by statute, and therefore that operates as an umbrella enhancement. It doesn't make sense to me that you wouldn't be able to craft something similar to that would cover violations of public trust or, public official.
Can I jump in? Lately, because of what's been going on in the world and nationally, I've been thinking a lot about our hate crime statutes that we passed a couple of years ago. Largely, as I recall, at the behest of the Jewish community, And we passed those through the General Assembly. And we didn't have to categorize every single crime. You have a crime and it's influenced by hate, and that's established at the trial, then there's a higher penalty. There's no reason why they couldn't do something similar to that in this case.
But is there a higher penalty or is it just a data collection?
No,
It is, okay.
If you not only get convicted of a crime, but also the jury or the judge, whoever's the trier of fact, concludes that the crime was influenced by hate, then the penalty is higher. There's no reason why we couldn't do something like that as the General Assembly in this case.
As an
If the
enhancement.
crime is committed, but it's committed by a public official, then there'd be a higher penalty associated.
But I think we're missing the point as to what she was talking about. She wasn't just talking about public officials. She was talking about people in a position of trust. So, I mean, otherwise you wouldn't have had all police officers and everyone else that was mentioned. So she's looking for a broader category to kind of.
Isn't that true with every case involving sexual crime? I mean, obviously not everyone. I mean, there are, the first degree rapes and whatnot, but the cases any case involving child abuse, any case involving sexual child abuse, the institutional sexual abuse, all of those cases involve the same problem that she's describing. So that it seems to be a broader.
But didn't she use the definition to say skillful or the education background? So that's what took it out for a parent and put it in the hands of the job. So like a teacher, like sex abuse with a teacher, a person of trust. That's what I understood that to mean.
Yeah, I know.
Yeah, I think that was a much broader
Yes.
request that is probably difficult because I don't even know how you fit that in. You always have to re-examine. We already figure victim injury and we contemplate that in sentencing guidelines. I think that would be a whole nother category. But I guess that was why I just said focusing only on misconduct in office. What we do, in fact, is we figure out appropriate categories for that. And I thought originally it was the 5-year, and I said, well, that's the category and that's what it should be. But maybe that is a classification issue that we do have some authority over. And as to Rick's point, Mr. Fincey's point, I agree. I don't think at all that our focus is because of whether it makes better negotiations for pleas. I don't think that is at all what our consideration should be. I think our consideration should be reflective, but we do see departures. And I liken it again to our discussion when we dealt with child pornography and the victim scoring on that. It was a recognition by the commission that perhaps we weren't reflecting the nature of the crime in its authentic nature. That's kind of what I see with misconduct in office, that we're kind of lumping in with other thefts that are not anywhere in the similar category as someone who is misconduct in office, because that is a public trust. And that was the only reason I suggested that. Not that we take action on it, but maybe it's worth exploring.
Is there anything from a research standpoint that would give us more insight into cases that may involve public officials but don't necessarily have the charge of misconduct in office, that would give us a more enhanced picture of any sentencing deviations?
I mean, not from the data that we currently have. The limited, what we were able to do is we can isolate cases that were prosecuted by the Office of the Maryland State Prosecutor. So that, our cases that, but they have they were very quick to point out that it's a much larger, significant number of cases that are being prosecuted by, the various state's attorney's office and the Office of the Attorney General.
So
but otherwise,
in what way though? I mean, because obviously there are public trust cases that are prosecuted by every state's attorney's office, but how are the state prosecutors' cases distinguishable?
Well, Ms. David did say to me that she could provide a list of prosecutors that primarily handled those cases. And so you could filter the data by specific prosecutors to figure it out. So for instance, you might know, Bob might not be in your office, but in like Montgomery County, she said it's always the same prosecutor who would handle those cases. So it would be one way to like try and filter out specific subset cases. So that was one idea that came up just a few days ago. That is something that we could explore further. I don't know how effective that would be in the smaller jurisdictions, though, right? Like
We don't have it.
Yeah.
Typically, what I see is the local prosecutor will have a case of substantive crime committed by someone in a position of trust, assault or even a robbery, whatever it is. And the misconduct in office is kind of an ancillary charge. And frankly,
It usually carries the lowest guideline.
correct, and it's just really a throw-in. And really, at least in the cases I'm familiar with, the only time we refer anything to the office of the state prosecutor is when the only thing we got is misconduct in office. Because that's what they specialize in. That's their jurisdiction is very narrow. I mean, they can't just take anything. It's got to be a misconduct in office type of crime, and then whatever might go along with it.
Can you refer misconduct, you can refer the thing to go along with it,
Can,
in addition to
yeah, but
misconduct.
we usually don't.
Usually keep it yourself.
Sure. I mean, that's just my little small office. I don't know what everybody.
I guess that's why I was curious, because if it's common law sentencing, I'd be curious, like what we classify some of the other common law sentencing. Because that's really like, if we're lumping it in with theft under $1,000, that's probably not as reflective on misconduct in office. If it's in the same category. I mean, that was just my thought. I mean, we're asking the legislature to change the sentencing, but we couldn't actually probably do more than that with a number, but.
The common law offenses are always difficult for us to classify. We do have to get into nuanced debates. Those of you who've been around long enough probably remember the very nuanced debate we got in about a fray, which we have, minimal number of convictions. And it was a very heated debate, you might remember. And there was a disagreement among judges on this commission about exactly what an affray is.
I have the only reported case in Maryland on it.
Oh, really? So that. Those are.
I'll tell you what it is.
There was very distinct disagreement
Definition.
about what that exactly an affray is.
Correct.
But we do have other common law offenses, but that is one where the commission does have to step in and kind of interpret what it is, because we don't have the guidance of what the statutory maximum penalty is. So, the other ones are like false. Senator West, you will appreciate when I brought up a table that I presented information on many years ago when on the first iteration of the crime classification task force about common law offenses, because that was something which I had suggested the crime classification task force should consider codifying the remaining common law offenses. But it's false imprisonment, affray, hindering a police officer, malfeasance, rioting, and the commission kind of has had to weigh in independently in terms of categorizing them.
Dave, can I ask, in terms of changing something like how we score the offender score, is that a legislative, does that come down from the legislator? Is that up to our commission to make a decision about that? Because it seems like something like having a vulnerable victim and you get 0-1, you get a point, right? It's sort of similar to saying, okay, abuse of trust, 0-1, maybe you get 1 point towards your offense score.
Right.
And it could apply to various different kinds of offenses. I agree not to a parent, right? It has to be a situation where special training or education or something like that, a unique position of power. But it just seems to me that there's a parallel there between a vulnerable victim and then an offender abusing their position of trust.
Right. I mean, the commission does have the authority to decide how those elements are scored. I mean, we are statutorily prescribed to have a range of sentences to account for increased severity as criminal history increases. That's not the way it's worded, but kind of, so the guidelines do need to account for criminal history and juvenile records.
But in this case, I think
in terms of how it's done,
it'd be the offense score, not the offender score, right?
Correct. It would be the offense score. Yes.
That only applies to person offenses as well.
And it only applies to person
That's
offenses.
part of
The additional elements.
And also vulnerable victim would cover already some of the
Some of them.
scenarios that they've presented.
Well, and some offenses require you to be in a position of trust to commit that offense, which we already score. So you would essentially be double scoring if we were
Isn't that
adding
true with the
that.
vulnerable victim too, like crimes that specify against a minor?
Yeah, we certainly will have vulnerable victims that'll be scored in those person offenses. And as well as the nature of the crime. For example, sex offense where a child abuse sexual offense where you have to have the care or custody or in a parental role already sort of would account for the position of trust in the severity of the sentence. So I think that's why it's a little different if we're categorizing it to all offenses versus a particular crime, which is misconduct in office. That that's why I think that to me, that the category that's in maybe is worth looking at. But I agree. I think adding the scoring could create a lot of unintended consequences for all types of offenses, because I think you can argue that on a lot of the offenses that we see. I mean, every person that works as a cashier that steals from the till is now in a position of trust, in theory. And I don't think we want to expand something like that, but the idea that our misconduct in office is very particular to the public trust. That's.
So.
I think the question is, where do we go from here? We've debated this now a couple of times. I think my suggestion would be that we go back to the guidelines subcommittee, focusing solely on the issue of misconduct in office. I think that's a little bit easier question to look at and maybe resolve. My position personally is it's underscored. The issue about across the board, I really think that's a legislative issue. That's recategorizing the sentences for dozens of crimes.
So for purposes of the classification, I would suggest, and this is a status report, we're not voting on it, but I would suggest that we go back to the staff and, let you all kind of brainstorm some ways to present the research on the classification issue. And yeah, if you have something new to offer the guidelines, then present it at the next guidelines subcommittee. If you don't, the guidelines subcommittee can still take up the issue. We really just tabled it last time to discuss the issue based on the information that we have. And, these are things that take time and contemplation. And I actually really appreciate having this before the entire commission tonight, because it's a complicated issue, and it's something that we should be thinking about. And, going back to the vulnerable victim, I mean, we debated that so intensely, and how to go about reflecting the sentencing without going too far. That was a very finely tuned and intense discussion that went on for some time. And that's really why we're here, is to give it the time that it needs. So in any event, I would recommend that we proceed in that way.
I'm not sure if this is included in your recommendation or not, but I would also recommend that the staff look at a way to collect data as a separate, perhaps, method of dealing with the issue. We could get to some of the other issues that the
It is difficult.
prosecutor's looking at.
It is difficult because I do think sometimes the offenses they'll go on are going to be the other offenses, because the guidelines are going to be greater than the misconduct in office, which is why it may not get captured. That sentence could be within guidelines, so there's no departure factor. We wouldn't know. It's a good point. Maybe there's a way to capture that.
It seems to me it would have to be on the worksheet, and you would have to
Right.
further.
I know Dr. Suda loves when we add to the worksheet.
Gotta find space on.
Yeah, there's always a problem with the worksheet.
Yeah, no, that's fair. I don't have answers tonight. I think we could bring some and see if we can come up with a way, but I think that's a fair job assignment for us to research and figure out how we might do that.
Good luck.
Anybody else want to weigh in?
I don't know the answer.
Lively
Thank you.
discussion? Okay.
All right, I think that concludes our discussion with the use of position, a trust position. So now I will move to Sarah to ask her to discuss the review of seriousness categories for select offenses.
Sure. So I'll refer you to that memo for the review of seriousness category classifications for select offenses. And again, this is just a status report. The guidelines subcommittee is not requesting any action from the commission at this time. As you all recall, the commission voted at its May 9th meeting to instruct the upper guidelines limits for offenses with mandatory consecutive sentences shall stack with those of their underlying offense. During the May meeting, Mr. Fincy expressed some concern that the new rule effectively double penalizes individuals convicted of some of these offenses. And that's because the commission already classified 3 of these offenses in higher seriousness categories to account for their mandatory consecutive sentences. And those offenses are knowingly violated criminal law article 5-602 with fentanyl, the use of a firearm, and commission of a felony or crime of violence subsequent, and the use of an assault weapon in the commission of a felony or crime of violence subsequent. In response, the guidelines subcommittee reviewed data for these offenses and their possible reclassification at its November 15th meeting. The analyses that the guidelines subcommittee evaluated are included at the end of the memo. Given that the rule doesn't go into effect until February 1 of 2024, the subcommittee opted to table this issue until we have sufficient data to evaluate the impact of the rule change on these 3 offenses. And so staff expect that it will take a minimum of 2 years after the rule change goes into effect to collect sufficient data, at which time we could reevaluate. And again, the subcommittee is not asking for any action. Any questions or concerns? Thank you.
Okay, great. If we can move on to the final video will take us through the introduction to the last topic of the subcommittee, which is the continued review of sentencing guidelines, departure reasons, and proposed judiciary solutions.
So I'll refer you to the memo, continued review of sentencing guidelines, departure reasons, and proposed judiciary survey. During its November 15th, 2023 meeting, the Guidelines Subcommittee continued its review of the listed sentencing guidelines departure reasons. The purpose of the review is to consider how the list of common departure reasons might be updated to more closely align with the reasons reflected in the current guidelines data, provide greater insight into the circumstances of the case, and help the MSCCSP identify potential sentencing guidelines revisions. The subcommittee unanimously approved the distribution of a short survey of the Maryland Circuit Court Judiciary to gather feedback on the revision of these listed departure reasons. The subcommittee provided feedback on a draft survey, and staff have updated the survey accordingly. The updated survey begins on page 3 of the provided memo. This survey solicits feedback regarding the current listed departure reasons and potential additions. The survey also provides space for comments or suggestions from the judiciary. At this time, the subcommittee requests that the commission approve this survey of the Maryland Circuit Court Judiciary to inform the revision of MSCCSP's listed reasons for sentencing guidelines departures. If approved by the commission, the MSCCSP chair and staff will then distribute the survey to the circuit court judges at the judicial conference in April 2024.
Thank you, Lydia. So just to follow up on that, the guidelines departure reasons, which we've now discussed for a few meetings, right? This started with the animal, the multiple animals issue and departure reasons, as you all know. Then the departure reasons haven't been revised since 2001. So they probably deserve a refresher, even if we hadn't had other reasons to look at them. And then we came up with the idea, I think Judge DiLeonardo and actually the staff independently were saying we really should get some input from judges about these reasons. And so Judge DiLeonardo came up with the idea to utilize the upcoming judicial conference in April 2024 as an opportunity to reach out to judges. And our idea is to, just do a brief presentation and discussion of this, and then give them an opportunity to complete, which is a relatively short survey. And I'm sorry that Judge Middleton stepped out of the room, because
So-
Judge Middleton is actually co-chairing the
Judicial conference.
the Judicial Conference Committee.
She has warrant duty, and
Oh.
she had to respond to a work-related
How dare she?
problem. Because I know she's been so generous in facilitating this, the presentation of the survey and the discussion about departure guidelines with the judiciary at our judicial conference. So we look forward to that.
And if I can add, so one of the things, and we talk about, like even here in our discussions today, is trying to capture really accurate reasons for the departures, because we rely on that so much when we're figuring out what to do with particular departures or guidelines. And I think it was a good opportunity when we're looking for more transparency in judicial sentencing and what we're doing and why the court does what it does, is to hopefully use that as an opportunity for our next judicial conference, to really stress to the judges the importance of these departures. I don't know that it's always known. I think sometimes boxes are checked because it's convenient, and not necessarily like it's easy to just, hey, well, I'll put it in this category, And the hope would be to really impress upon them how much the commission relies on these and their reasons for the departure. I know it's an afterthought a lot of times after some of the judges' sentence, and they get the email that, oh, you didn't get your guidelines in, right? And everybody's trying to get their guidelines. To really impress upon them how much we rely on it, and how much, honestly, people ask the commission for data and resources in making policy decisions, including our legislature. I think the accuracy of that data is really important. So the hope is just to, obviously it's not a reason the judges doesn't restrain them, but it helps inform, I think, the public why the judges are doing what they're doing. And I think it really informs us not only what the reasoning for the change, why there's a departure, we know that, but really the justification for it hopefully will help us. So, Judge Avery, you have anything to add on that?
Well, I just think that having this presented at our judicial conference is going to be really useful. We've had so much turnover in the judiciary with new judges, and it's really educational for judges to understand the purpose of the guidelines. And like Judge DiLeonardo said, that it's not just about checking boxes. It's about informing this body of trends and feelings among judges in terms of sentencing, and that what they tell us is very important in how we proceed, because we are only here to reflect back to judges what the average sentencing is for typical sentences. And so involving the sentencing judges in this conversation, I think, is going to be very useful for judges as well as for us.
And I'll just even add to that point is there was a lot of discussion, and there's been discussion previously about getting data on the judges and why they're sentencing a certain way. Maybe some people perceive it's too light, but that's why when we're talking about mitigating reasons, a recommendation of the state's attorney, that's not checked. And that would, if it is checked and that's the reason, that helps inform that the judge was following the recommendation of the state. It's just an example. Or if, for example, you see some below, again, as it becomes more and more transparent, given those reasons in court and on the record, so documents really important. Judge Shaw, I didn't mean to.
I just wanted to ask about the presentation, because I think it would be important that the judges understand in the survey that they would not be identified, that all of their responses would be confidential. And I know that in here that you said that you would have a QR code and the judges could respond through that. And I would just suggest that that be done during the course of your presentation, as opposed to having the judges do it afterwards, because we might not.
Well, yeah, we appreciate all that input of what do you think is the best format.
I mean, I'll
Obviously, Judge
I'll
Mills
also
will go back
defer
in.
to my colleagues over here, but I think it's easier when you're sitting there and you're doing it right then and there. as
Well,
you-
that was one of the reasons for presenting it at the conference, that hopefully Chief Justice Fader talked to him. I think I said, well, once I found out the commission was interested to do that, talk to him and get his support on this to try to really get, because the problem is these surveys would get sent out and a few will respond, and it wouldn't really accomplish what we're trying to accomplish. So it's a great opportunity to just get a lot of feedback on how this will best use for the end user. So I agree with you.
Well,
Either that or we give away pens if you complete something. But we'll find something.
I'm curious because I wonder if you're having judges use a QR code, if you can identify on the screen the percentage of judges who have responded to the survey at the time. And so, kind of like
That would be interesting.
yeah, to show, when you have at least a critical mass. But I have another question about this too, which is that are we only addressing circuit court judges, or are we presenting this during a plenary with everyone?
Good time for me to come back into the room. So I am one of the co-chairs of the judicial conference. What we discussed were two things. One is possibly presenting it during the business meeting, but that is the chief judge's business meeting. The alternative proposed is to present it during the circuit court judges breakout session. But now that I hear that there may be QR codes and everything, so I thought that you needed like 25 minutes. How much time did you need?
I think 25 minutes would be very sufficient. I think we would start Judge DiLeonardo providing a brief introduction, much like he just did, explaining why they're important, why we collect that data,
And I did think
and then
the
giving the
circuit
opportunity to do the survey, which the survey is pretty brief. We estimate 5 to 10 minutes to complete.
I'm not rushing you. I'm just thinking
No, that's okay.
about time. So we anticipated about 25 minutes. In my mind, I envision you all going first. But I don't think that it's something that's difficult, and they incorporate surveys and questions all the time. So it shouldn't be something that's difficult to accomplish. But I thought during the circuit court specific.
Yeah, and that's what I thought, even if we went from room to room, like they're broken out, that I thought perhaps it would be one of those things that could be announced as like, after we do those presentations, to make sure people have done them in the larger room, just as a reminder. But I felt like that would be a perfect way to just talk to the circuit court judges about the importance of it.
Can I suggest that district court judges and appellate judges need to have an understanding of the sentencing guideline process and the work? And so we have district court judges who are elevated to be circuit court judges. And we have appellate judges who never served as circuit court judges. And so to a certain extent, I believe there maybe should be some general information that's provided to everyone. And maybe just the survey to circuit court judges. But I think the information is important and it's valuable to
So
everyone.
maybe there's a benefit to a general discussion of the importance and the need for the feedbacks, so people understand the process. And then perhaps in the smaller room, we push the survey.
There may be district court judges who aren't even aware.
Right, we got some.
Well, a lot of district court
Most of
judges
the judges-
actually refer to the guidelines too. I mean, even though, guidelines are present in district court, even though they're not required. And so I agree with Judge Shaw 100% that the commission's presentation would be really useful for the general
It
body.
can just be a short presentation.
Right.
But
I
And we
will
did-
take it back to the.
we don't have to decide, we don't have to
We can
decide that
certainly
tonight. What we're asking this commission to do though is vote to approve the
Right.
the
Doing the-
administration of a survey to the circuit court judges. So, yeah.
Second.
All right, any further discussion? All those in favor of presenting the,
Oh, I'm sorry, I just have one quick question. Distributing the survey is obviously, a great start and a great idea. But where do we go from there? What's the next step? In looking over the departures and reading the history, that the staff has prepared, like, these have been unchanged since 2001. In looking them over and thinking about it, I was kind of, just personally, I was kind of shocked. Like, I'm looking at the list of reasons for departure below the guidelines, it doesn't include youthful age. And we've had, since 2001, we've had all, Miller and Graham, and we've had a succession of Supreme Court cases that have, emphasized, and I'm going back to think, in defending death penalty cases, there were actually statutory mitigating factors, and youthful age was one of them, and substantial impairment for a mental disorder, or mental disability. That was another one of them. And even though those were, you had to consider them if it was found in a death penalty, we don't see an analog in these enhancements. And I can only think that, there just hasn't been, there's been so much that's changed since 2001. We had Atkins versus Virginia dealing with, the death penalty of those with intellectual disability. Now, that has to be considered as a mitigating circumstance. So I'm just wondering what the next step would
I could
be
address that.
in looking at these
Right.
that have been ossified as of 2001, and what do we do to bring them
Well,
up?
I think you've hit on the key points. That we did have some of those discussions already on the subcommittee. The next step is to get feedback from the judiciary, have our own research, and kind of taking that all into combination, considering what proposed amendments we may have in terms of departure reasons. I will note that offender's age is one of the more commonly provided reasons written in other, and that's listed out in Appendix B. You can see what other reasons have been written in. So I think it's reasonable that we would probably list that. We would amend some of the current and now include that and some of the other commonly listed other reasons that are there now. So getting back to your question, next step is to take all this information and come forward with proposed amendments for these departure reasons at a subsequent meeting.
Thank you.
and that was really, and part of it, putting it to the judges, was the fact that, we get some of them are just generic or not, so it's like, okay, what are your reasons? And it was really to help inform the process. They had already come up with a tremendous amount of ideas, and it was just essentially to give the judges an opportunity to weigh in, or emphasize what they think's important. But I agree, offender age is one of them that was listed in the proposed options. That is something that they could, in fact, say, yes, this is one that I would use.
So I think we had a motion and
We
a
have a
second.
motion and a second. All those in favor say aye.
Aye.
Anyone opposed? All right. Well, we will depend on Judge Middleton to get us a seat at the table now. That's what the free meal was for.
Pressure.
Thank you.
All right. So with that, we move on now to the executive director report.
Okay, thank you. I have 5 items to review. First, regarding the first item is to discuss November 13th, 2023 sentencing guidelines revisions that have been adopted. The Sentencing Commission issued a new version of the guidelines offense table and adopted corresponding updates in the Code of Maryland Regulations effective November 13th, 2023. These updates include the classification of new and amended offenses passed during the 2023 legislative session, the classification of 3 previously unclassified offenses, revised seriousness categories for subsequent drug offenses with 40-year maximum penalties, and other minor edits to the table. These updates were highlighted in the November 13, 2023 Guidelines e-news that was distributed on that same date. The second item I want to update is regarding recent guidelines trainings and feedback meetings. On the 18th of September, I presented at the Conference of Circuit Judges meeting to ask the Conference of Circuit Judges to recommend to the Judicial Education Subcommittee that sentencing guidelines training be mandatory for law clerks working with judges on their criminal docket. As those of you might remember, this is something that we discussed at a previous meeting sometime earlier this year, I believe. Judge Shaw, I think that was your recommendation, if I remember correctly. The Conference of Circuit Judges voted unanimously to make this recommendation to the Judiciary Education Committee.
Thank you.
So I'm happy to share that. I also wanted to note that since our last meeting in September, the staff have conducted 6 webinar training sessions. On September 6th and September 15th, the Sentencing Commission Training Coordinator, Catherine Pembroke, she conducted and provided MAGS 101 training for law clerks and court staff. And then on the 20th and 29th of September, Ms. Pembroke also provided MAGS and Sentencing Guidelines 101 sessions for prosecutors, defense attorneys, and probation and parole investigators. So typically those who initiate the sentencing guidelines. Ms. Pembroke also conducted a question and answer session or webinar for law clerks and court staff on November 3rd and conducted another similar question and answer session on November 8th. This is a new format that we are trying out. We thought it was kind of a quicker, shorter format of the traditional webinar, and we think it was pretty well received. We asked, for people to submit questions in advance and give them an opportunity to ask any questions that they may have. I can't tell you that we received an overwhelming number of questions submitted in advance, but we pulled out a few of the more commonly received ones that we get via phone or via email and used it as an opportunity to answer those. And I think the people that participated in those sessions thought that the format went really well. So I think we'll continue to do that going forward. Additionally, I met with judges and court staff, as well as representatives from the county state's attorney's offices and the local district public defender's offices in 2 jurisdictions since our last meeting. Specifically, the meetings were completed in Mr. Harvey's jurisdiction in Calvert County on October 19th and in Anne Arundel County on October 30th. And so my goal with those meetings is to meet, I try to meet in each jurisdiction every 2 to 3 years, and the meetings are a great opportunity to share sentencing guidelines data and discuss recent guidelines updates and review the work of the commission, and finally to solicit feedback regarding the guidelines and the work of the commission. So I really think that those meetings are a really great opportunity to get more of a one-on-one audience with the local jurisdictions. And, we in Calvert County, we got into a discussion about departure reasons, et cetera. So that was, I always think those are great opportunities. The next item I wanted to discuss is just to do a review of the protocol for the Sentencing Commission response to legislative proposals. So in 2019, this commission adopted a protocol for responding to legislative proposals. So basically responding to legislation that is proposed that specifically affects the work and activities of the Sentencing Commission. I'm not talking about the standard bills that would, propose a new penalty or increase or decrease a penalty for a particular offense. Those are standard operating procedures that the Sentencing Commission would, deal with on a routine basis. As you all know, usually at our July meeting, we classify any new or amended offenses. So what I am referring to is bills that specifically have the potential to affect the Sentencing Commission beyond its routine operations. And given that this commission typically does not meet during the legislative session, we adopted a policy to guide our responses to legislation that directly affects either changing the way the sentencing guidelines work or operations of the Sentencing Commission. So that policy, which I did include in the materials that were emailed to all of you, just adopts a protocol of the following: that the Sentencing Commission staff would identify those type of proposals and will assess how they affect the sentencing guidelines or the Sentencing Commission's operations. The staff will then promptly notify the chair of such proposals. And then the chair or the Sentencing Commission staff will schedule a conference call, or more likely probably a Zoom meeting at this point. In 2019, it was pre-Zoom, to do a video conference for the full commission. And that the purpose of that is to solicit feedback from the full commission and to request a vote whether the Sentencing Commission is going to support, oppose, or take no position on proposed legislation. And then the Sentencing Commission will make sure to publicize that meeting, because any type of meeting we had like that needs to be publicly available. So we would make sure that that information was available on our website for anyone to participate and or to observe. The Sentencing Commission would adopt the majority position of the voting commission members, provided that we were able to get a quorum. And then the chair and the Sentencing Guidelines Subcommittee would convene in a timely manner to consider that particular legislation after receiving the position of the full commission, and decide whether it is necessary, and if so, to present the position of the commission to the legislative committees, legislative leadership, and or the governor. Then the staff, in conjunction with the chair and the subcommittee, would prepare any formal testimony for relevant sentence and House bill hearings. So this came up because in 2018 and 2019, there was legislation introduced that was going to have a significant impact on the work of the Sentencing Commission. And so we kind of decided at that time, our then chair decided we need to have a formal protocol. I think that was under Judge Harrell, who said, like, we don't really have a formal protocol of how we're going to handle this. So we adopted this policy. So I just wanted to review that. I know we have new commission members who haven't been with us since that time. So that's the policy that we do plan to follow should legislation be introduced this upcoming session. So just wanted to ask if there are any questions regarding that regarding those procedures.
Just to be really clear, it typically is legislation that is asking something of the commission or asking to change the mission of the commission. That's what we're really talking about, not all the other bills we don't take positions on. It's really those issues. In those particular years, I think there was a number of bills that were coming forth, was asking the commission to either collect data, issue data, do different things. And we thought it was important for the community to weigh in on those issues. So that was primarily
right.
And sometimes we're getting asked to, we're trying to drag the commission into some issues. But I think since then, has it happened maybe twice?
Right. 2 or 3 times.
So it's not that common, but
No.
when it happens, it's really important to try to get everybody involved.
I think things have calmed down a little bit.
Yeah, it's not as active as it was then. That's for sure.
Senator West.
Just a note, and Charles agreed with this. It's not uncommon for hearing dates to be set not too long before the hearings actually occur. So whoever's in charge of this is going to have to check the listing every single day. You can identify the bills earlier on that you're interested in, but you need to check it each day, because one of those bills can be set for hearing like 8 days later.
Oh, we're well aware. Yep, that happened last time. Yep. Yep, it does. It does happen very quickly. Yeah, we'll be on top of it.
And sometimes that may be testimony or a submission of a letter. We at least try to get it
Okay, the next item I wanted to do is provide a progress report regarding another committee, the Task Force to Study Transparency Standards for States Attorneys. And Senator Sidnor is smiling at me. Senator Sidnor is one of the co-chairs of that task force, along with our other commissioner, Delegate Moon, who's not here tonight. But so I wanted to give an update on that because it does have some impact on the Sentencing Commission. So for those of you who have been with us for a while, you may recall that during the 2022 legislative session, the General Assembly passed Senate Bill 763, and that was titled the Maryland Criminal Justice Data Transparency Act. There were many provisions in Senate Bill 763. One of them was that the Sentencing Commission is now required to produce a new annual report regarding crimes of violence. And we did have to start doing that as of last year's it's due same time as our annual report. And so last year was the first year we did that. We were also required to create and publish a data dashboard about crimes of violence. So that Senate Bill 763 was also responsible for that. But additionally, Senate Bill 763 also created this task force to study transparency standards for states' attorneys. And the task force is required to develop processes by which prosecutors can collect information and determine what information should be made public and what information may be kept private. Second, examine any existing policies of states' attorneys' offices across the state relating to the transparency of data, the charging of crimes, and sentencing. By virtue of my position as the executive director of the Sentencing Commission, I am one of the appointed members to this task force. As I mentioned, the task force is co-chaired by Senator Sidnor and Delegate Moon. That task force has met 4 times, starting on October 18th of this year and most recently on November 28th. During these 4 meetings, the task force received multiple informative presentations, including presentations from the Maryland States Attorneys Association regarding existing transparency policies from individual prosecutors' offices, and also we heard about their existing case management systems. Additionally, the director of Reshaping Prosecution from the Vera Institute of Justice presented about best practices and national standards regarding prosecutorial data transparency. We also heard from a group of researchers, including our commissioner, Dr. Brian Johnson, who are working in collaboration with a group called Prosecutorial Performance Indicators, or PPI, to analyze prosecutor data from states' attorneys' offices around the country, but most relevant to us here in Maryland, they are working, I think, currently with 4 or 5 jurisdictions in Maryland, including Baltimore City, Charles County, Frederick County, and Montgomery County. So we heard a little bit about that work and what data and information they've been able to collect from the individual prosecutor's office there. At the most recent meeting on November 28th, the task force agreed to a proposal to create a statewide uniform procedure to collect data and a plan for providing one-time startup costs to either upgrade or implement more modern technology in local prosecutors' offices. The task force also agreed on certain basic information states attorneys should collect, such as age, race, and gender of victims and defendants. The task force also discussed the collection of additional data points, such as offense type, felony misdemeanor indication, initial charge, final charge, cases that are declined, cases that are dismissed, reasons for case dismissal, cases resolved via plea versus trial, and whether diversion was offered. Co-chairs Sidnor and Moon really have done a great job. This is, it's a tough topic to tackle, and so they really have done a good job. We've heard input from a really diverse group of voices that are working to achieve some consensus regarding the final recommendations. And the co-chairs also indicated that they would meet the Governor's Office of Crime Prevention, Youth, and Victim Services to analyze, to assess how, what type of funding might be available towards one-time setup costs for case management system. The task force will report its findings and recommendations to the Senate Judicial Proceedings Committee and the House Judiciary Committee by the end of this year. I think I would be remiss if I didn't give Senator Sidnor an opportunity if he would like to add anything that I may have missed regarding that task force.
You did a very good job of talking to what it was that we did do, and I appreciated your time and service on the board. But the Delegate Moon and I we tried to find some sort of consensus for recommendations to put forth, and something that would be very basic after learning that not all state's attorneys' offices had content management systems, CMSs. And so we wanted to make certain that we crawled before we walked. We were initially also looking at transparency, but we want to make certain that we're at least collecting the data before we get to that next step. So we actually did have a conversation with the Governor's Office on Friday, which was fruitful. And we have a homework assignment, collecting some information, reporting back to her, and she's going to be looking to see how they can be helpful as well. So thank you all.
Great. Okay. the last item that I will provide an update on is regarding the Sentencing Commission's annual report. So our annual report is due on January 31st, 2024. And staff has begun preparations for the annual report already. We are in the process of doing data cleaning. Yay. A lot of fun on that. It's pretty tedious if you didn't know what my sarcastic yay was. But we are working through that right now. And our plan is to distribute a draft for you all to review on or about January 17th. So I know you'll be waiting eagerly to receive your draft, but that's about when we intend to send it to you, at which point I will give you 1 week to respectively read that and review it and offer any comments, edits, suggestions for us so we can make sure that we meet our, we can incorporate any feedback or any changes that we need to do and submit the report by the required due date of January 31st. In conjunction, the report now does require the additional report on crimes of violence and an update to the data dashboard, which we are now publishing. So we will do that at the same time at the end of January. So that concludes my report. I am, of course, happy to answer or address any questions.
Yeah, thanks for the updates, Dave. I'm just curious, you said that there were consequences for the commission based on the transparency task force. I guess I'm wondering what those are, but also, is there going to be a mechanism for taking the data collection that's going to be generated from prosecutor's office and somehow use it to inform the commission data? I know Judge Karoum came and talked actually during a public hearing about a year or two ago and was making a case that one of the issues with the sentencing commission data is so many of the cases are negotiated pleas. And so it seems like this could be useful, having some information on the plea process to inform some of our data analysis. So I'm just wondering what that would look like.
Right. It's hard to say. Did I say there would be consequences for the Sentencing Commission?
Oh, you said it was relevant.
Yeah. Well, I do think it's relevant. Well, yes, I definitely think it's relevant. I will be honest, and Senator Sidnor and I had a lot of conversations about this. I was worried that the consequence would be that the Sentencing Commission should start collecting all of this additional data about charging information, which I stress would be very difficult to do because the guidelines aren't based on charges. It is based on final convictions. And so we didn't think the guidelines worksheet would be the appropriate mechanism to collect information about any charges that are dismissed, dropped, but to your secondary point, which is probably the larger point, yeah, I do think the data will be, when it is collected, will be relevant to informing this commission. Absolutely. So I think it's really important for us to understand that information. As we've kind of said before, we talked about this a lot with the race report, right? That's kind of the big bit of missing information that we don't have, right? Our race report really looked at the final stage, and we are looking at sentencing decisions. But it's, as we all know, it's all that other criminal justice decisions that come well before the sentencing process that can ultimately affect those outcomes and any disparities that we may see. So it is really important for us to understand how the initial charge and if there are disparities in charging decisions and how that can ultimately affect sentencing outcomes. So I know that was a long-winded answer, which I think is, it sounds like we're on a good track for getting some agreement about the case management and how that information will be collected. But ultimately, I am hopeful that that information will be really useful to the Sentencing Commission and a lot of others who are interested in learning a more fuller picture of the process.
And if I may say, with the agency formerly known as GOCAP, they have a number of analysts that work with them. So one of the other things that we talked about is if the funding is going to be coming to state's attorney's offices to help them to either update their systems or to have their to actually create or fund their systems, there may have to be some strings attached so that they are reporting back to that agency so that they can collect it. They could create data dashboards if need be. So we're having those discussions as well.
Great, thanks.
Thank you, Dr. Slay. Next, our action item is our meeting dates for 2024. We have Tuesday, May 7th of 2024, and that would be an in-person. Is that correct? We generally have
Yeah,
done
that's, you're
2
right.
and 2.
You're right. I appreciate, I did not properly decide in advance whether we would make each of these. Sorry, we could do this on the fly. We've kind of gone with, I know there's, we've kind of gone with 2 meetings in person and 2 meetings virtual. I know everyone, I think in person is great, but I think some of us also appreciate the ability to do some virtual meetings. So the way we did it last year was we did, or this current year, I should say, we had this meeting and the May meeting in person, and the July and September meeting. July is always the toughest meeting because summer months and vacations, et cetera. So I think keeping that virtual makes sense. And
I think that's what we did last year. So
Yeah.
obviously this one has to be really in person.
Right.
Because we have public comment. And then I think what we did was May being, it's certainly when we're getting past legislative session, that sometimes we'll have a lot of issues to discuss, so that has been sent to the subcommittee. And at least July and September, having it as a virtual meeting.
Yep.
That seemed to work this year. Is that good with everybody? Okay. So those are the meeting dates that are listed. And as I just said, May 7th would be in person. That would be here. July 9th of 2024 would be a virtual meeting. September 10th of 2024 virtual meeting. And December 3rd would be both for public comment and in-person meeting, which again would be here. Is there a motion to accept it?
So moved.
All right, second?
Second.
Any further discussion? Hearing none, all those in favor say aye. Anyone opposed? Okay, those are our meetings. Any old business? I do have one, and not to put you on the spot, Dr. Souley, but you mentioned the race report that
Right.
was fabulous, that I know all of you put a tremendous amount of time in. I'm just curious, what, if any, feedback since it was submitted that we've had? Didn't mean to throw the curveball at you.
No, that's okay.
You brought it up, I thought about that, and I was interested to hear, like, if you had received any feedback from the report since it had been submitted to the legislative body.
We have not received any specific report. I've definitely discussed it with some, interested individuals, researchers, members, but there hasn't been any specific feedback or call to action, based on some of the recommendations that were made in the report.
I was just wanted to ask. Any other old business? No? New business. So I know we have
Yes.
one special piece of new business, and we'll hand it to Dr. Souley.
Okay. So I do want to very happy. This is a great new business to report. So I'm just really honored to have the opportunity to recognize Judge Avery. So Judge Avery has served as the Vice Chair of the Sentencing Commission since July 2015 and served as the Chair of the Sentencing Guidelines Subcommittee for the same 8-year duration. She previously served on the Sentencing Commission for 4 years, from 2007 to 2010, in a prior role as the designated representative of the Department of Public Safety and Correctional Services. So she's put in a lot of time here with the Sentencing Commission. So she's most recently completed two full 4-year terms as the Vice Chair and Chair of the Subcommittee. And it is our expectation that a new Circuit Court representative will be named in her place starting next year in 2024. So we wanted to take this opportunity to thank Judge Avery, because we didn't want to miss this opportunity, since this could very well be her last meeting, and we wanted to recognize her significant contributions and service. So, as I think most of you probably know, she's very dedicated to the work of the Sentencing Commission, and she's thoughtful in her deliberations, in chairing the Sentencing Guidelines Subcommittee, and I just want you to know how much we appreciate that. I think it's really important to the work of the Sentencing Commission. During her 8-year term, the subcommittee and this commission has tackled several important tasks, which include, but are not limited to, but some of the most important ones that I wanted to highlight, an assessment of racial differences in Maryland guidelines, eligible sentencing events, which we talked about, the adoption of revisions to the sentencing matrices for the drug and property offenses, adoption of the revised scoring instructions for the juvenile record to reduce the impact of disparate commitment practices, and finally, a study on alternatives to incarceration and corresponding recommendations to enhance awareness about the availability of appropriate alternative sanctions. And I know all of those projects were really important to Judge Avery, and we just wanted to say how much we appreciated all the guidance that you helped provide to this commission over those years. So, in conclusion, on behalf of the Sentencing Commission and the staff, it is my honor to present this plaque to Avery. Try to bring out so everyone can see. In recognition and grateful appreciation for your dedicated service to citizens of Maryland as the Vice Chair of the Maryland State Commission on Criminal Sentencing Policy and the Chair of the Guidelines Subcommittee from 2015 to 2023. So we thank you for your positive and lasting difference your service has made towards developing and maintaining fair and equitable sentencing practices. Policy in our state. So thank you so much for accepting this appointment. We will certainly miss you.
I wasn't asked to give a speech, but I have to say, I will just say this, that the work on this commission has been extremely meaningful. And for those of you who are new to the commission, I just encourage you to engage and bring everything you have to the table, because it's really important work. And working with David and the staff of the commission has been just a privilege of my career. Frankly, I've learned so much more from you and from members of this commission than I brought to the table. And for that, I will always be grateful. Thank you.
I want to add, having been on the commission previously and then come back in again, for those of you, especially I haven't been part of it, the legislative subcommittee is an incredible amount of work that goes on behind the scenes. When we come in and you see the recommendations, it's a lot of discussion. It's a lot of very thoughtful discussion. And Judge Avery has led that for many, many years. And really the success of when we come in and you hear their recommendations, sometimes they're all in agreement. I will guarantee you they don't always start off all in agreement, right? And that is really a testament to Judge Avery and her ability to find that common ground in sometimes very disparate positions. And I also want to note that in the time that I've seen her in these positions, having a real dedicated and true center on the purpose of the commission and why we do the work we do, and always very vigilant in protecting that and making sure that we're all kept honest about the importance of the commission and that we don't stray from that mission. So I've just, having seen that and sat through so many of these subcommittees. I know Rick certainly has been involved in all of those, so Sidnor now and Bob as well. But even prior to that, I've seen the iterations when I was in Bob's seat previously as part of the subcommittee. I always had a lot of respect for the way that you handled that. And so you will definitely be nice.
Thank you.
Any other comments or new announcements? No? Well, that's the way to end it then.
Yeah, that's good.
Well, again, I want to thank everyone very much. I know to come down and to take time out of your schedule to do that, but it is very important. It's great to see everyone again. I hope everyone has a great holiday. With that, I'll take a motion to adjourn. All right, we're adjourned.
All right, good night, everyone.